Peace, everyone. Welcome to the Moroccan Post School of Government and International Law. We have the Moorish. Please, hit that like button, subscribe. All right. We have a wonderful class for you today. This is part 3 of the Moorish Consular Relations, Moorish Treaty Protection and Consular Relations, our 201 course. This is part 3 of the Writ of Quo Warranto, a section of the 201 course. We have a sample Quo Warranto, Shem that Shem Malachi Bey drafted a few years back.
Okay.
So we have my upcoming lecture in Jonesboro, Georgia. We have there's been a change in date. That's February 19th, 2023. And we have a guest speaker. I can't read that though. So we have a guest speaker.
Okay.
Go ahead.
So the key speaker is Abdullah Bey, as you can see up there on the top right.
Read it.
Then you have host Seymour Bey. The topic is going to be, or the topic is, I'm sorry, the untold history and science of Black America. The location, or in fact, it's going to be in February 19th, 2003. Doors open at 7 p.m. This is going to be in Jonesboro, Georgia, 7827 Old Merrill Road, Jonesboro, Georgia. Area code, what is that? Zip code is 30236. Also, you're going to have a guest speaker. What's his name, Abdullah?
Matavu no more. And then he is telling who he is. Read that.
Royal Ambassador at Large Etker Kingdom Alliance, 750 kingdoms in the alliance. This event will take place on a radio station, I believe, Abdullah?
No, it won't be on the radio station. Seymour Bey works for the radio station.
Mm-hmm.
Seymour Bey works for the radio station. It will be at the radio station. It will not be on the radio station.
Oh, okay.
So that's one of the sponsors. One of the space sponsors. Seymour Bey works for the radio station. All right.
Right.
So it will not be aired live.
All
Not
right.
be aired live on the station.
All right. So that's
the
Power WSTV Atlanta 104.9. So, all right.
Now put the Eventbrite information, be the bottom.
The Eventbrite information. Where do we see that at here? I don't see Eventbrite, but I do see up at the top there, it says 21 and over is will be 50 notes. 13 plus, it'll be 25. And for children, it'll be free.
Children under 13 free.
Yes, children under 13 free. Okay. Let's see. The Eventbrite, here it is. Search the untold history and science of Black America on Eventbrite. And that's where you can pick up your tickets on there. All right, back to you, Abdullah.
All right. We have another slide.
Sure, we can just do, we can show the class here. In 1 second. And this is just showing the class for today, Moroccan Post School of Government and International Law. Shem Malachi Bey will be going over the Writ of Quo Warranto sample. And then later we will be getting into the questions You want to speak about that, Abdullah, about the questions will
Yes,
be?
the questions, there's 27 questions that that'll be placed, that will be in my upcoming book, not Moore's Mason Part 2. I have other upcoming books. Moore's Mason Part 2 is the most recent upcoming book. But I have another upcoming book coming this fall, the Definitive Peace Treaty between Great Britain and the United States as the 1783 Definitive Peace Treaty between Great Britain and the United States as the ruling instrument for the United States. Those 27 questions will be read tonight. The introduction to that will be part of my book. So this is also going to be I've already started pre-marketing my book on Sunday on the Moroccan Post as well as Crumb TV. I've already begun pre-marketing my book. So it'll be 6 or 7 months of hard pre-marketing of this upcoming book. Moore's Mason Part 2 will be out next month. That is the most recent upcoming book. But this book here will be out this fall. And we're going to spend from 9 to 10. Amanda will read all 27 questions. So read the introduction and all 27 questions. Next 2 weeks from now, both on Wednesday and Sunday, 2 weeks from now on the Moroccan Post, on Crumb TV, we're gonna do all 27 questions, but I'll be able to answer it. I'll be doing so Shem will not be presenting. Shem will not be presenting in 2 weeks. I'm gonna go 3 hours. So I'll go 3 hours. I'll be doing solo. I'll be doing solo on the 2 weeks from now, that Wednesday, and then I'll also do the second Sunday. All right, and this is a preview. This is very important because we have to address the misconceptions that Moors are part and parcel of the United States. And so this is a heavy dose of addressing the misconceptions that I taught for 25 years to thousands of people. All right, so we'll get right to it. The Moroccan Post School for Government International Law presents my man, our main teacher, Shem Malachi Bey. Yeah, he deserves that. That's right. Give it up. Give it up.
Peace.
All right.
All right, so we're gonna bring up the we can have a reader.
Sure.
Amanda's gonna be doing a lot of reading. Can we have a reader? Another reader.
All right.
I'm gonna have to step away because Alexandria, the sister we talked to, she's asking about the some code. So I gotta let me talk to her. All right, so bring somebody. Amanda, you'll read because I have to step away. I have to call Sister Alexandria.
Right.
Okay. In the Consular Court, Republic of Morocco,
T,
Western.
make it a little larger, T.
All right. Let's see what I can do here for you. How about that?
Yeah, that's not bad. I can see.
Hold on. Let me see if I can stretch it out a little bit more.
You mean the letters more bold?
How about that?
Yes, good. I normally can widen my I can't widen on here.
Yeah.
I don't know why I can't widen.
I'm not sure what's going on with that, Shem. Oh, let me try something here.
I normally can widen my hands, widen the document with my hands.
Let me do this real quick for you. I'm gonna see if I can shape it out a little bit better for you. Hold on, I got you. I'm sorry, Amanda.
That's okay.
1 hot second. Let me see if we can blow it up for Shem a little bit. Okay. Let's see here. Is that any better?
Yeah, somewhat good. That's good. I do the best I can do.
Okay. Yeah, I got it. This is all the way across my screen. I can't do
Can
it.
we, hey, Shem, I mean, Terrence, can you shift that to, I
That's
can't
good for me.
see it.
I deal with it like that. I have to deal with it like that. Go ahead.
Hold on.
Can we share it with somebody else that can, whose screen can be larger? Because I can't see it. Amanda? You make her the co-host, Shem, and she can, I mean, Terrence, and she can,
Yeah, hold on. Let's see here.
I don't have this though.
oh, you don't have that?
No, and
No, I'm
I
saying-
one from the class.
I would have to send it to her.
Oh, you have to send it to her. Oh, that's how that works. Oh, my bad. I didn't know. I mean,
Yeah.
All right. Can you see it, Amanda?
Yeah.
All right.
All right.
I don't know why it's so small, man.
Yeah, I wouldn't be too sure, y'all.
What does it? Will it appear small on the screen when people view it? Record the recording?
No, it's not. It's all the way across the screen.
Yeah, it's all the way across my screen.
All right, go. That's good. I'm on my phone.
Start from the top. Start from the top.
There you go.
In the Consular Court of the United Republica of Morocco, Western North Morocco Civil Division.
Okay, let me explain what's going on. Let me explain why you got to file in that court. That's when the counselor have the jurisdiction from the government for international affairs, meaning that, say the matter has been, somebody filed a claim in state court, and that matter, and that court don't have jurisdiction. What the council does is go ahead and do a removal based on a treaty, international law, to get a federal court docket number for it to be moved out of state court jurisdiction who don't have power to hear it. Once that is done, then you take that file number you got from the federal court with that petition, and you attach to a notice of removal in that state court and attach that as a exhibit, and file it is removed. Then you go to the Mukti court of the Moorish government court, and you do a notice of petition to remove in that court and attach the federal removal petition and the state notice of removal to that notice of petition removal in that court and file it in federal court. Now, a notice of removal from the federal court to the Moorish court, to a consular court. Now, what happens in international law, the only one can hear and litigate that matter is the consular, because the consular is international judicial officer for that government. I mean, both governments stipulated that any dispute happen, criminal or civil, the consular should have jurisdiction. When you give a jurisdiction to hear something, you only want to make a judicial determination. So therefore, that gives the consular right now to make a determination on a writ. Meaning that by what authority do any entity or corporate government have to exercise jurisdiction over memorial? Based on what law? In other words, what Moorish government do a legislative act created you and delegates you power to hear Moorish claims or settle Moorish disputes? That's very important. You must understand that. What legislative act of a Moorish government gave you that power? Or what treaty did the Moorish surrender that authority to that foreign government to hear foreign matters? When a writ is filed, what authority do they have? What delegation authority do you have? You will have none. So the council has to make a decision here. When a writ gets filed, you give them 30 days to respond. If they don't respond, then the council will issue a judgment on a pleading and enforce that writ. So it benefit all the Moors. So when now anything ever happen in the future, any Moor can rely on this writ and say, well, it was decided by the council under international law that didn't have jurisdiction. That's it. Based on that form case number, it's over. Yeah, go ahead, man. You finish me. I'm gonna explain that.
Hold on, Shem. That was awesome, brother. Let me that was awesome. That you said a lot of proper concepts, Do we have any questions before Amanda continues to read? Because you really went into the procedure, and well, we're gonna have to write that process down. We're gonna continue with this, with the we might even need another class on this. We'll see. I'll make that determination. See
Okay.
how much, you know.
All right,
this is very
Professor.
involved.
All right.
Okay. Petition for writ of Quo Warranto memorandum of law. The above named sheik or sheikess respectfully petition the district court to issue a writ of Quo Warranto to respondent Jane Cook, Attorney General, requiring her, 1, to show by what authority or power delegated to her pertaining to the 1778 treaty between the Lenni Lenape Moors and the United States Delaware Treaty, Treaty of Navigation and Commerce between Great Britain and the United States of 1796, the J Treaty, and Treaty of Peace and Friendship between His Imperial Majesty Emperor of Morocco and the de jure United States of North America of 1787 and 1836, pursuant to the constitutional authority she is trying to usurp without an appropriation by law. 2, or an absence of showing, to require her and her successor to cease and desist from any further judicial authority being usurped without an appropriation by contract law.
Let me explain this. Let me explain what's going on here. When anytime the first Congress, Confederacy, was given amnesty and asylum by the Lenape Moors. They're not Indians, they're Moors. They gave them asylum and they protected them. They took them in refuge. The United States, matter of fact, the United States is called refuge. They're refuge. They were taken in with asylum into a foreign jurisdiction, foreign land, and it was given asylum there, and it was given amnesty as a friend. By doing that, they established their first capital under the Confederacy, and they wrote their first corporate charter called the Articles of Corporation. That's the first corporate charter. They were all separate states operated independently. Therefore, the delegated to Congress, each of them delegated certain portion of their sovereignty to a Congress to operate, to speak on their behalf when they're doing business with foreign governments. So you got to understand, the reason why you got the Lenape Treaty there, because that's the first one that acknowledged them. Then you got the treaty with Great Britain also acknowledging them, allowing them to go back in the colonies to form a central body, corporation. Then you got what you call the Kingdom of Morocco, acknowledging them on Northwest African soils, doing business in the colony territory. As they formerly did business with their parent, their mother, Great Britain, they also the emperor extended them friendship, harmony, like extended Great Britain hundreds of years ago, allowed them to be here too, to see the land to them do business here. So that's very important. That we know why. Let them know under these treaties, when did the United States or any of its corporate created through legislative acts was given power by the treaty, by any emperor, king, or queen? Who gave you that power to delegate authority over Moors? Where'd you get that delegated authority from? In other words, if it's not in a treaty, no legislative government can give it to you, because they're not Moors. They're not considered as Moors operating on behalf of the Moors government, delegated power from the Moors government. So therefore, they have no power to litigate or make decisions on any civil criminal matter. As a matter of fact, make any political determination, legislative act affecting the Moors. That means they have no power. So you challenge that anybody that's claiming to exercise jurisdictional power to speak on behalf of a Moor or litigate, make a decision on behalf of a Moor or make laws to benefit a Moor, there's no delegation authority to allow you to do that. Where's the instrument at? Where's the legislative act for the Moors government allowing you to do that? Giving that foreign government to do that. After that happens, the Moors government got to come back and create a legislative act now, so the rest of the Moors governments, domestic governments, that know that the United States or the Great Britain got that power to regulate commerce over the Moors. There's no legislative act coming from Moorish government or in a treaty, so it doesn't exist. They don't have power. They have no delegation authority. Any questions? While we go on this way, any questions?
This is a very key concept, and Yannick, you and I were talking about this today. This is a very, very, once we get this, we're on our way. Once we are solid on this, We are on our way. We're on our way. This is a major, major, major concept. And what the issue is, Shem, it's what you're saying is not complicated, Shem. It's because of the misconceptions. Not what you're saying is not complicated. We have conscious Moors will battle the misconceptions as they listen to you. It's the misconceptions. They measure, they're going to measure what you say by misconceptions taught by conscious Moors. And so the misconceptions are at the forefront. They hear you saying a different tune. You know, so well, I'm take the treaty into the court. And then Shem will say, let's look at the language in the treaty. Yeah, but depends on the subject. It depends on, does the treaty, whatever you say, let's go to the language in the treaty. This is a major concept. And because of the years of misconception. So we're gonna have to, this is great, man. You're doing a wonderful job, Shem. I salute you, brother.
And I want to jump, I'm here, I'm glad Professor Abdullah brought this up. We have to understand that the Moors were operating in a different province. The Lenape Moors had a province inside Morocco called Sheikh Mexam, Lenahoki, Susquehanna. These are the territories of the Moor subject nations that were operating independently in the Moors' dominion, they were protected by the Emperor of Morocco. Now, let me explain something to you. The Moors, the Lenape Moors made it clear in the treaty. See, Abdullah, thank you. You brought an important point up. The backup of Abdullah saying, go to the treaty. The Lenape Moors explained that any Moors that any contrary with any United States courts, that if they're going to be trial, a matter before him, only the Lenape, they got to be half of the Lenape. It got to be a Lenape Moors, native Moors, that be able to litigate that case, adjudicate that case. That's very important. That's in the treaty. Now, what are you talking about, Shem? That's called negotiation inside the treaty. It set a mandate in the treaty that if a Moor is arrested for any kind of crime or civil matter, he have a right to have a jury of his peers, of Lenape Moors. Not in your opinion. You can't, no citizen of the state. And the council is a deputy of the Lenape nation is the one that can enforce that. A deputy is another word for a council. That's all. You operate for that government, the Lenape government. Please hear me out. The treaty, see what Abdul just said is in that treaty. The treaty delegated authority to the men in Congress that if you do anything dealing with a Lenape Moor, you got to do it based on these terms. And that's very important. I'm glad Abdullah brought that up. Read the treaty. Please read this stuff. Now, somebody say this concept, they are part and partial. The Moors are part and partial of the United States. No, they're not, because they didn't want to say a jury of their own peers. That means you have to have a jury of your people, your nationality, not theirs. So if you part and partial, there was no need to have a, see, let me say something to you. When you part and partial with somebody, there's no need to sign a treaty. If they sign the Constitution, why they sign a treaty? They don't need to sign a treaty. They're already part of the Confederacy, the union they formed. If they're part of the union, why would they sign a treaty? Does that make any sense? The days and the days.
Shem, what we're gonna do, we're gonna present evidence, because instead of asking the right questions, the guide to critical thinking. So instead of our raising questions, we are presenting evidence. That's what James and I did. James Weeks Bay, myself, we did in May. Amanda, can you put that in the link? Are Moore's part and parcel, or someone, Shem or Terrence, put in the chat. Are Moore's part and parcel of this said government. That was on Com TV in May of 2022. You put that in the chat. Your homework assignment is to watch that. It's a PowerPoint presentation. So we analyze through presenting, and we present documentary evidence. We show the signatory page of the Articles of Confederation. So not only do we raise questions, we actually show evidence pointing that Moors are not part and parcel. Meaning, we say Moors are not part and parcel. We are presenting evidence to support our claim. Our claim is Moors are not part and parcel of this said government. We have evidence to support our claim. All right, we have evidence to support our claim.
Yes.
All right, brother Clint, put that in your homework assignment, is to watch that Moors part and parcel of United States. All right,
Yes.
thank you today. King, you have the floor.
Okay, I just got a couple of questions. One would be, who is the custodian of the treaties, of these various treaties? And what is the threshold that Moors must accomplish as this application to be applied under these treaties for full enforcement?
All right, let me answer that. I'll do the second question. All right. Let's go to the Montevideo Convention. The Montevideo Convention, the acts and duties of states. In the Montevideo Convention and acts and duties of states, you have a constitution, independence, a permanent population, the qualifications for statehood. Montevideo Convention acts and duties of states, so that you're not going to say Abdullah said anything. Montevideo Convention acts and duties of states. The qualifications for statehood. Permanent population. Government. And there's two more. But pull up the acts and duties, the requirement for statehood, the Montevideo Convention. All right, thank you. All right, because this is for everybody. So this is how you answer the question. I'm answering King's question by giving him references. All right, based on principles of the laws of nation of dealing with statehood. So that's the qualifications. All right, so who are the custodians? The custodians. Let's go to the treaty. The answer, the only way anyone in the world can answer King's first question. Only way in the world for anyone to answer the question, King's first question, is you got to go to the treaty. All right. Who are the parties to the treaty? The Moroccan Empire. Oh, so the Moroccan Empire is the custodian.
The depository. That's right. The depository of the instrument. That's right.
I mean, what I'm doing is I'm making it plain.
Yes, that's right.
Let's not overcomplicate this stuff.
Yes,
that's good. It ain't all that. It's go to the treaty, the Moroccan Empire, and I know, King, you're going to say it on it. Yes, it does. Means that we got to restore. That means we have to restore the power. We have to reorganize. But the Moroccan Empire, all right, it's a pre-existing sovereignty. That's our birthright. That's our birthright. Is to restore, is to reconnect, to exercise that pre-existing sovereignty. That is our inherent right. So now that we know that the Moroccan Empire is the custodian, what do we need to do to bring the Moroccan Empire out of her 200-year period of political extinction, collapse, disintegration, dismemberment due to European conquest, European subjugation, and European colonization? What do we need to do? We're doing it. Education. Educate the people. The 12-week session course on the Moroccan Post Media YouTube page. Moorish body politic formation, constitutional and governmental principles on the Moroccan Post Media YouTube page. We did that from March 2021 to September 2021. We have the Moorish body politic, the Moorish treaty protection and consular relations 101, 10 sessions that we just finished up 2 months ago. We're now in the Moorish treaty protection and consular relations 201 course. We have on the House of Reawakening the Mind, 20 sessions. Shem Malachi Bey joined me on the House of Reawakening the Mind in November 2019, from November 2019 to November 2021. For 2 straight years, Shem Malachi Bey joined me. So we got over 20, and I sent them to Sirius. I sent each one to Brother Sirius. He's going to download them, all right? So we have a host, Facebook presentations. We have classes, we have other courses. So what we did on Sunday, Yannick, Elkanan, and Sirius, and myself, along with Terrence, we presented a national network organized by regions. We have a plan of action. We have strategic plan of action. Did you see the flyer? Connected to the radio station, connected to the brother, Matavu. Our connections are growing and growing and growing. Shem, you have the floor.
Yes, that is perfect. I'm gonna add to what the professor is saying is that the International Convention lays down every self-sufficient, self-dependent, self-determined community as a state have a right to be their own depositor. What you mean? By the instrument being placed in the control of that self-determined state or community, is their right as depository holders to enforce the instrument. They hold it. Therefore, by being a state existing, an old state existing in the Empire of Morocco, they have the same right as if they were the Sultan themselves to force that in their political arena. Self-determined. That means they take the treaty, they make a self-determination and deposit it. They become, let me tell you about custodian. Once they got the treaty and they hold it in a depository as value, that they're the custodian, the government. They automatically become a custodian. They got a right to enforce it. No different than going to a courtroom and handing it to the clerk in the courtroom. The clerk places with the document, the evidence. Okay, who's the custodian of that court document? The courts, the judge. So by being part of that government, the judge becomes a custodian of the holder of court records. The clerk becomes a custodian. Why? Because they're self-determined by that government. They delegate authority to do that. The same way with us. No different. Anything else?
Any other questions?
I did see a question in the chat by TM Bay. Would you like to state your question and have it on the video? Because someone else might have that question and you might want to have it answered aloud.
Islam.
Yes.
All right. So the question is, are tribal nations considered independent states within the Moroccan Empire?
Okay,
And if so, two part. If so, what document unites them?
okay, let me say something. When you say tribal, what are you talking about?
Yeah. Yes. Qualifying.
Are you using the
No,
terminology as
Shem,
Indian?
Shem, ask him. No, have him. When you just ask him that question. Just ask that question.
Are you when you say tribal, are you talking about the Moorish societies, communities, or are you talking about what the Europeans claim the Moors to be when they nationalized them through language? What you mean when you say tribal?
Indian. As Indian.
Yes, as Indian. What you mean when you say tribal?
What I mean is the independent named tribal nations, like, you know, I'm just saying, the commonly, let me put it this way, commonly known as tribal nations.
Okay, I got you. Let me say this here. First of all, when you say the word tribe, you're talking about a host of communities and societies forming that makes that tribe up. That's called a clan, houses. There's a group. That's a variety of houses that form a community that becomes a society that's called a tribe. That's of itself is the nation. Yes. Now what it is that they have a right to delegate among themselves authority to govern them in their own land, their own regions, their own territory, providence. That's their right. All those tribes that come together and form what you call a confederacy or sign a treaty among themselves. Because each tribe is considered sovereign, even though they live in the same land, they consider sovereign in their own domain, in their own political territory. They consider as sovereigns. Well, how they sovereign? Because they got a right to self-determine in their own land who they are, to make their laws and delegate to certain men and women to hold certain seats of government, official seats of government. So when you say tribal, yes, a tribe could be a government because a tribe is up in a community, a society of houses. That's all. So a kinsman. So yes, they can be a government and they can come on themselves and sign a treaty. Not only on themselves and sign a treaty, they can enter one national compact constitution. And that become the mother. What do you mean, a birth of what? The birth of a new creature, a new identity that they're gonna be operating under. That means when they go sign a constitution, that's a mother. Out of that mother coming what? A new creature, a new entity, organization they're creating that all of them operate, exercise sovereignty through that one government, that one creature. So they become the masculine, the father. The Constitution becomes a mother because the Constitution gonna be the thing that's gonna nourish the children later on for centuries, for thousands of years. That Constitution, if it's still in power, will still be a thing that nourish feminine. That's the feminine part of it. The Constitution, where the creature a child come from. You understand?
Islam. So the second part to that is, if so, what document unites all of the tribal communities within the Moorish Empire?
A treaty in the Constitution, a national convention. Okay. All tribes sending forth all their delegation of authority who they elected to go out. Once he leave or she leave, they got all the full power as if the king or the chief or the queen of the tribe would have. They have all the power vested in them. When they sign a document, they're vested or they're obligated on that tribe. Because the representative, official, the delegated authority, full authority, when he signed or she signed, then the tribe become liable to that one instrument. You understand?
Yes, actually.
Keep their phone down. Just keep your phone down. Shem, keep your phone down.
Anybody got questions?
Like that. Keep your phone like that.
Okay, anybody got questions?
You keep moving your phone around.
Okay, my bad. Anybody got more questions?
You rocking.
I'm my share, Abdullah. I'm my share, Morocco.
I know, but it's your phone is.
I know. I make sure it'll go up. So I know. You got me. You got.
He doesn't get me. He doesn't.
Can I ask another question since nobody else is on the floor? Can I ask one more question?
Yes, go ahead. Yes, sir.
Okay, is there a historical document that unites all tribal nations under the Moroccan Empire? That's my original question. Is there a historical document?
I haven't read one. But what I'm gonna say is this right here.
All right.
Because the Sultan, see, this is what me have to do. Professor have to do is refer back to Doc and looking back. Now I'm gonna ask you a question about looking back. So let's go back. When Persia was conquered by Greece, when Greece lost its power to the Roman Empire, when the Roman Empire was conquered by the Sultans, was claimed to be a direct descendant of Prophet Muhammad. The Sultan was the Muhammad followers. So when the Sultan conquered Italy and took over the power for the Pope and conquered Constantinople, the Sultan inherited all the spoils of the empires. It conquered Denmark, it conquered France, Spain. Why? Because all of it was French, all of it were Roman states. They were controlled by the Roman Empire and later controlled by the Pope. When they beat the Pope out in the Roman Empire, they became the spoils of all the European power. That's the spoils when you win a war. All the spoils fall over to the winner of the war. Under surrender, under doctrine of surrender. That means all.
But that doesn't. You're not answering his question. I hear you, but that doesn't.
I'm gonna get there. No, there's no doctrine.
Get there, brother. Get there, because that doesn't answer his question.
No, there's no historic document where all the Moors came together among themselves and signed independent states or tribes as in the Empire of Morocco. No, there's no document. I have never read no document, no such document like that.
That's the answer. That's your answer. Your answer is your answer to Shem. Your answer is that I have not read. I am not aware of such document existing. That's your answer. I'm not aware of such document existing. Let's just keep it at that. That's it. Just keep it at that.
Okay. Anything else? Anybody got anything else?
Can I go further?
We got to get back to the.
Okay. All right. I'm just trying to get to. I'm trying to just so you know, all I'm trying to do is try to answer in my mind why the Lenape would sign a treaty with the United States independent of the Moorish Empire. That's my question.
Well, I explained that already. I said when the Sultans conquered Northwest Africa, all parts of Africa, and it became part of the Moroccan Empire, the extended part of the Sultan power. A lot of the tribes here were still considered as sovereign, the chiefs, the kings, and the queens. The Sultan does not disturb the domestic power of these governments because by allowing them to operate in a sovereign capacity, he didn't disturb their power. See, for some reasons, a lot of time, if you go back and read, a lot of kingdoms are like that. Egypt, go back and read Egypt, Babylon. When they conquered nations, when they took the spoil, they allow a lot of the nations to keep their sovereignty, maintain sovereignty among themselves. Why? So there will be no cries of war. See, wars divide a kingdom, an empire. So let them operate in sovereignty as long as they don't rise up against us. Let them govern their own people. That way we have no obligation, no responsibility.
Let's wrap it up. Shem. Go ahead. Let's go right to the listening. Come on, let's wrap it up. That's it, brother. Yes. So we go right to the document. We already asked 3 questions already. Come on, let's go. Let's go right to the document.
Go ahead.
Additionally.
Oh, okay, go ahead.
No, go ahead. Those let you know where we are.
Okay, additionally, the petitioner seeks a judgment against the officials and the state of Pennsylvania for the cost of litigation, including attorney's fees, because the district attorneys and municipal or county officers are representing the state in their official capacity as officers of the local and state government.
Now, when I draft this up, I put in there like that. That would be how the Moors would draft it up. They operate as if it was delegated authority for the Moorish government, delegates the authority to operate and hear matters over Moorish affairs, because it wasn't the sheik or the council, the sheik or the Marco, because he had another one for council. They had local authority called, I think it's M-O or M-U-S-U-L, M-O-S-U-L, Mosul. So the sheik is the one assisting the council. So therefore, the judge consultant or the sheik will be the one that have to be paid for helping out the council to push forth the litigated matters. Go ahead, Amanda.
Introduction. The petitioner seeks a resolution from this court of the United States constitutional claims pursuant to the state and municipal officers of the agencies, office, and departments that usurped authority that is neither delegated to the district attorney nor any of the state's agents, representatives, and agencies, departments, or courts.
Now, I kept that regular because to show somebody the full that how when someone of the state, when Attorney General go to the federal court and say that an officer of the state of, let's say New York go to the federal court, say the Attorney General, the state of New Jersey is trying to do my job. He was not delegated authority by the people of New York or by the legislative, or by the parliament, legislative power of New York to do certain functions for New York. Therefore, that's abuse of power. He's serving authority that he wasn't delegated. So I left that part in like that, put the United States in there to show you that this is how the Moorish court is supposed to operate. Exactly how the draft is. Stop someone from exercising authority that it was not delegated authority to do. Just go back to Professor Abdullah was saying. When the Moors go into a courtroom in front of a judge, the first thing, in order for the judge to get jurisdiction, is when you file a document in that court with the heading of that court or the matter, the court's got power to speak. That's why they dismiss a lot of matters. They're able to speak and dismiss it because they know rightfully they don't have jurisdiction. They know that. So when they read it, the caption gives them power to speak is addressed to that court, who was delegated authority by act of that legislative act, a power them to speak. When any matter brought before them, they have power to speak. But when they read it, when they litigate it, they read it, they say, wait a minute, we talking about the substance of the person that's bringing the claim, the body. Who is the person? Is this person a citizen of the state? Or say the person say, I'm a citizen of New York, bringing the claim in your court because a citizen of New York violated my rights. The New Jersey court is not going to litigate that. You know why? They will tell you, they say, well, somebody in the state of New Jersey violated my rights. I'm a citizen of the state of New York. The court's going to dismiss it and say, you have to file your claim in the what? The federal court based on what? The Constitution, based on constitutional law. So if the judge ruled on that case, you can let it have that case, you can have it removed based on a Quo Warranto, say you don't have authority, have it dismissed because you don't have authority. The judge, the court, the New Jersey ruled on the matter because I'm a citizen of New York. New Jersey say, well, you can't file a claim in this court. I'm a citizen of New Jersey. And the court of New Jersey would dismiss it and say you have to remove it to the federal court because we don't have jurisdiction here to matter, a foreign matter between citizens, disputes between citizens of different states. So if the judge rule and grant a summary judgment on appeal, the party for New York, New Jersey can have that case overturned based on appeal because the judge is not delegated authority to rule on a matter on a New York claim. Can't do it. Or Jersey claim because he's a foreign citizen.
My man.
I just want to break that down if we go along so nobody made the wrong concept.
I gotta salute you, brother.
Go ahead, man.
Treaty of Peace and Friendship between His Imperial Majesty Emperor of Morocco and the de jure United States of North America of 1787 and 1836. Treaty of Peace and Friendship between the Bey and subjects of Tripoli and the de jure United States of North America of 1796. Treaty of Navigation and Commerce between Great Britain and the United States of 1796, the Jay Treaty. Only delegate authority to a Moorish consul or pursuant to the General Jay Treaty between Morocco and Great Britain of 1856. That authority is delegated to the Moorish consul that appoint the Moorish sheikh to litigate all civil and criminal disputes between Moors and British subjects and United States citizens. And these treaties are self-executing. And the only mandatory authority pursuant to the Supremacy Clause in the Constitution of the de jure United States of North America.
Go ahead.
The
Somebody was calling.
petitioner, okay. The
I-
petitioner, sorry.
Let me just what you read up top. See, the reason why you bring in the treaties is because that is the legislative acts of both government in that treaty. They embody, just like if the government, that government itself went to the floor, had a bill, put the floor or act on the floor, and then enact the act or legislative act to force the act in their own political jurisdiction dominion. That treaty operates as a legislative act passed by both governments, signed and ratified by both governments, meaning that it is the law of the land. That's why I say it's the law of the land. All judges got to obey it because it holds the same weight as a legislative act if it was passed by the domestic government, by their own house or a parliament by itself. That means that when they sign that treaty and the parliament ratified, that means that's like a legislative act ratified itself by that parliament by agreeing to that. You understand? Anybody got any questions on that? I go ahead, man. Nobody got questions? Read on.
All right. Replacing.
The petitioner claims that such actions injured him or her and other Moors as the appointed sheikh operating under the religious Barbary codes in the jurisdictional boundary within the British, French, and Spanish political zones, and as an alien with immunity pursuant to the treaties said herein above, and whose rights are protected by Moorish treaties, barring and restricting respondents who are allegedly usurping the Moorish consul and Moorish sheikh offices of the Moorish government.
Yes.
The petitioner is an officer sheikh of a Moroccan society and minister of a mosque with standing to challenge respondents' unconstitutional expenditures and illegal actions as well.
Now, what happened is now the sheikh is coming in, showing what kind of power is delegated to him by that government. That he's the only one got power to hear that matter. So that's called a special appearance. The sheikh now is making a special appearance through this Quo Warranto. Go ahead, man.
Jurisdiction. 1, this court has original jurisdiction to hear this Quo Warranto and this petition for writ of Quo Warranto pursuant to 28 U.S.C. Code Section 1651, Section B, and ancillary claims for litigation is pursuant to Article 3, Section 2, Clause 1 of the Constitution of the de jure United States to enforce the Treaty of Peace and Friendship between His Imperial Majesty, Emperor of Morocco, and the de jure United States of North America of 1787 and 1836. Treaty of Peace and Friendship between the Bey and subjects of Tripoli and the de jure United States of North America of 1796. Treaty of Navigation and Commerce between Great Britain and the United States of 1796, the Jay Treaty, only delegate authority to a Moorish consul or pursuant to the 1856, the treaty between Morocco and Great Britain is mandatory conferred pursuant to the Supremacy Clause of the Constitution of the de jure United States and other applicable authorities.
So what happened is the codes that I got above, all of those, they got United States statutes, there will be statutes of the Moorish government. The Moorish government will have their statutes. And international law, there was a central authority. CFR, the rules of federal regulations, dealing with international law, all that stuff will go in there, give the council power to exercise its jurisdictional authority on these treaties in that foreign zone, the foreign dominion of the European powers. Go ahead, Amanda.
As the Sheikh of the Barbary Society and Minister of the Mosque of a Free State has ratified the United Nations Declaration of Rights of Indigenous People in our position as the descendants and blood pedigree of the Deys, Beys, Viziers, Caliphs, Emirs, and Moorish Moroccan nationals.
Now what happened there now is you exercise your authority by claiming that that we deal with kinship now. Just call it inheritance. What gives I mean the government now is making a claim that the officers that are able to hear this are native Moors. That's all it means. You native Moors. They don't even have power to make this litigation, and the governments agree. The ancient governments of Morocco agree to allow to only give the Treaty of Granada. Number one, there's treaties that set up self-executed treaties the only law of Moors, the Moorish government to litigate the Days and Bay treaties, the treaty between the Moroccan Empire and the United States or Great Britain or wherever it is. They delegate authority to the Moorish Council or their council when dealing with their nationals. So this is why it's very important. See, we have to know that in order to benefit us all, that's why we come together and sign a treaty and do a national constitution. That is the mother vehicle to bring birth to the new creature that's being created, which is us, which we all gonna be what? We are a new creature. All of us come together and go into our mother to be the birth a new what? A new child. That child represents all of us as an heir now. Once the national government is an heir to the Moorish empires that was already established. All that sovereignty that the Sultan got, we got it now. Any questions? Make this very clear. All the
Right.
power. Anybody got any thoughts? How we
We have a question.
how we able to do this? We
That's
able
a,
to do
that's
it
a
because
hand.
go ahead. Question?
Hand up.
No, that was a hand clap. That was a hand up. That was not
Oh,
a hand
hand
up.
clap.
That was
The hand
Okay.
clap.
yes.
Yes,
All
go
right.
ahead.
Hand clap.
We don't man that man.
Uh,
Go on.
we do have King. King, go ahead.
Oh,
You
his
have the
hands
floor.
up. All right.
Can I ask you a question, Shem?
Yes.
For as the international community, the doctrine of law sovereignty, the doctrine of what is it? The doctrine of reclaim was a reclamation. Can we use those because those are international fundamental principles of the international community? These are doctrines that the United States recognize. Could we put certain doctrines in our writs to say that these principles align with the fundamental principles of the international community?
Okay. Abdullah read earlier the fundamental principles and standards, the obligations that a state got to have to be considered as a state body. Number one, once that's fulfilled, you don't have to prove nothing to the United States. Let me go back. Let's look back now. When the United States want to self-determine among themselves, what they did, they came together as political communities and went to Great Britain and negotiated through the esquires. They met with the esquires, they appointed the esquires, because that's who all Great Britain was going to talk to, esquires. It was not going to talk to the common people. They're not worth enough, the subjects. A king and a queen and a princess does not talk to commons. They talk to someone that they delegate authority to speak with the commons and see where they agree with that. That's what happened in the Constitution. Now, look at the United States. When they decide to self-determine among themselves, that was honored and respected. That's an old ancient principle among any people. Once you go to the United Nations and do this, you don't have to worry about the United States. They have absolutely they have to go by this because now this is the same principle when they sign up for the League of Nations. They rely on this principle to keep them self-sustained, self-sufficient as independent states. No different than like New Jersey. If New Jersey say, I'm going to cede for the Union, what New Jersey would have to do first is notify Great Britain, France, because they signed a treaty, Great Britain, France, and Spain, that we are no longer considered as part of the United States. We're going back at their old charter. They notify the ambassadors of the crowns that gave them power, their parents, their mother, that gave them power to operate in these jurisdictional territories of Morocco. Then they go to the Hague, they go to the United Nations, declare themselves independent as an independent state, operating in Northwest Africa or in America in the British, French, and Spanish zone. When they do that, they're not part of the United States. They don't need the United States. As a self-government body of people, they can do it themselves. You understand? I use that scenario to show you how it's done.
Well, New Jersey already has, New Jersey, right, already has authority from Great Britain. New Jersey already has the authority from Great Britain by virtue of the 17th, this is from 9 to 10, when Shem goes off. New Jersey, so since Shem brought that up, I'm only bringing it up.
Yes.
So New Jersey already has authority from Great Britain by virtue of Article 1 of the 1783 definitive peace treaty between Great Britain and the United States. United States viz, namely, all 13 are named. New Jersey as New Jersey state, by virtue of Article 1 of that definitive peace treaty, 1783,
Go ahead, do
are
it.
claiming rights on the New Jersey Colony Charter. New
Yes.
Jersey already, the state already has that, so they don't need to go to Great Britain. They don't, like, New Jersey does not need to go to Great Britain when they already have that. The Article 1 of the definitive peace treaty, they acknowledges His Britannic Majesty recognizes them as individually independent.
Thank you.
Each
Right.
state,
That's right. Go
New
ahead.
Jersey state,
That's right.
not the United, New Jersey state has authority through that treaty to operate on the Moorish soil and the British zone, the territory boundaries that laid out in the New Jersey Colony Charter. That's a proprietary colony charter for
Yes.
24 proprietors. They already have that. They don't have that. They don't need to go to the United States to
That's right.
operate. They don't, because the United States didn't give them that. The His Britannic Majesty. They already have that.
That's right, Abdullah. We getting there. That's right. I'm glad I came up now because Abdullah would address this anyway about that first article. And now this question was asked. Thank you, Professor. It ran you right to that question. You wasn't asked anyway about that treaty. Now you're able to define that. Thank you very much. Go,
That'll come up in
Amanda.
another 45 minutes. That'll come up in another 45 minutes. So we'll get to it.
Yeah,
All
we
right.
get to it. Yeah, I only got to it because Shem said something that I wanted to qualify.
Absolutely.
All right.
You're good, brother.
That was beautiful, Abdullah. That was beautiful. That was great.
All right.
Constitutional provisions. 2. Article 6 of the Supremacy Clause of the de jure United States of North America Constitution expressly makes it clear that treaties are the law of the land and is mandatory self-arbitrary decree that it operates as the authorized powers over the state's executive, legislative, and judiciary pertaining to alien and national status pursuant to treaties.
Go, Amanda. Keep going. Keep going.
3. Article 6, the Supremacy Clause, prohibits the United States executive, legislative, and judiciary branches from exercising the power as the Moorish, Moroccan consul, or Indian deputy on the treaty's merit, facts, and norms that are self-executed by the language written within the treaty herself. Article 12, the Jay Treaty of 1796 and the 1796 Treaty of Tripoli self-executed power between both governments. Delegation of authority. The treaty between Great Britain and the de jure United States of North America is self-evidence that indigenous and aboriginal Moors and the associated bands of Indians, American Indians, have the treaty protection to travel and navigate through the land, air, and waters or jurisdictions and venue in the British Dominions realm, and the Treaty of Peace and Friendship between the Bay and subjects of Tripoli and the de jure United States of North America of 1796 is self-evidence and as self-executed, which delegate power to the consul of the Moorish government to hear and decide all disputes pertaining to Moors pursuant to the treaty. This treaty makes it very clear in plain language that all disputes, either civil or criminal, shall be decided by the Moorish consul or Moorish deputy. No representative, agent, attorney, judge of the state of Pennsylvania, Commonwealth of Pennsylvania, shall exercise any of the powers properly and respectfully delegated to the Moorish consul or Moorish deputy expressly provided in the treaty between both contracting parties that sign the instrument.
Yes. Keep going.
4. Article 6 of the Constitution of de jure United States of North America provides that treaties are the law of the land, and the states are bound to obey and enforce it in its political jurisdictional boundaries pursuant to the self-executed language as the law as follows. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all the treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every.
Let me say something before you read any further. See, there was two United States, one the Confederacy and the one that all the states give all their power to one central body. Now, under the Articles of Confederacy, any treaty the United States entered into was considered as a contract. This is why the Constitution said no one shall impair the obligation of contract. Why does the privacy clause and the articles say no one shall impair the obligation of contract? I'm gonna tell you why. Because the Esquires are working for the crowns and the privacy council, the royal family of these crowns. When they wrote the Constitution, they made them put in there that the grants, any patents or grants that was given by the kings or any charters, as a contract from the king. It cannot be impaired by this new government that's being formed. The new government cannot impair the obligation. And the treaties that entered into, when you ratify this, any treaty you sign after you ratify this Constitution, it's still binding. It's binding before and after. It's binding against the United States. As under the Confederacy, they were bound by what? French, Little Moorish treaties, Spain treaties. They were bound by these treaties before they even signed, before they even put together the Constitution, and they also borrowed money from France, Spain, aid them in the war against Great Britain. Therefore, by aid them in the war, they signed treaties, and the treaties they ceded a lot of put this stuff on obligation. With Great Britain, they borrowed tons of money, and they had to pay it back. So what happened is these had to be honored. So the Esquires wrote in the Constitution that these treaties of the law of the land contracts. What's the contract? Letters of grant patent to the letters of grant patent that were given to the charters, that were given to the princes of children, the successors, the law proprietors, their children of Spain, Denmark, Great Britain, all these foreign empires. So when the Esquires wrote that, they made sure that these are let me explain something. These are legislative power. They've written the Constitution. I mean, any legislative act passed by Congress cannot be passed against this Constitution, destroying it. I mean, if Congress passed an act and said that they got power, that the United States got power to regulate commerce without what I consider outside the treaty, that's no good. That's de facto. I mean, Congress is operating in a de facto office capacity. Therefore, Congress was not delegated authority to write that act, the legislative act. It was not delegated any authority. What you mean, Shem? The treaties delegate all the power to the new United States. Nothing else. That's all they go about with the treaties and the contracts, the engagements they entered into. Before ratifying that Constitution, as it was under the Confederacy, no different. Whoever carried for the Confederacy came over to the new United States, became bound against them. Anything they signed as the new United States, it also became obligated against the United States. This is why I say you cannot say that the Moors are part and partial with the United States, because first of all, look at the signature page. There's no days or bays or Khalis or Sharifs signed that Constitution. Number one, there's no more states of the Union that was subject to Great Britain, that fought against Great Britain, and was part of that treaty. There's no more states that's identified Article 1.
You did it, brother. That's it.
You
That's
understand?
it. That's part of that treaty. There you go.
That's right.
Got it. That's
There's no more state or community
that
or
definitive
dominion.
peace treaty between
That's
Great
right.
Britain.
In Article 1, the Great Britain granted them to go back into the colony. They have to do that. They was already sovereign. So the treaty reached for itself. So if somebody said report partial to Article 1 of the treaty, a peace and friendship with Great Britain, the United States does not name any more nations, states, or nations. That's the end of it. It's gone. The argument is big.
Shem, let me just slow this down, because you made a great point. I don't want it to get lost.
Yes.
You made a great point that I didn't make, point that I wasn't going to make between 9 and 10. I wasn't going to make this point between 9 and 10, this point that I didn't think about. So I want to appreciate you That's a great point. Definitive peace treaty between Great Article 1 of the definitive peace treaty between Great Britain and the United States. There's no more states. United States viz. Article 1 of the definitive peace treaty. There's 13. None of them are more states.
That's right. Absolutely. That's still an argument.
None of them are more. So all right. The misconceptions that I taught for 25 years to thousands of people is that we always started with 1787. We always started with the Constitution Moors being. So we're now taking it back. So if Moors are part and parcel, there's no more states that's no more states that signed the Articles of Confederation. There's no more states that are listed as part of the viz, namely, that's named in the definitive peace treaty between Great Britain and United States, 1783. You gotta tie that. We always, conscious Moors who taught that misconception, and I was one of them, starts with 1787. We gonna bust this thing wide open, y'all. We busted it wide open. All right, he taking a break somewhere. All right. Any questions? Comments, criticism. Well, let me say this. Our Shem is gone. The writ of Quo Warranto, there are some conscious Moors who have been misusing the writ of Quo Warranto. They don't understand it. They don't know what it is. They don't know the purpose of it. There's conscious Moors have been using the writ of Quo Warranto to address offenses. You know, this judge so-and-so did this. No, you don't address offenses. You address does that judge have authority to be a judge? Not that the judge did this or that. Not in the writ, that's not in the writ of Quo Warranto. You don't address any offenses relative to a judge not doing his duty right. You know, judge, no, that's not, you don't understand the writ. You don't understand the writ. You address the issue, a citizen of the United States, petitions for a writ of Quo Warranto against a judge. That would be to see the challenge whether the judge was duly elected as a judge, whether that natural person on the bench is duly and rightfully a judge. That's all. That's it. That's all. Not he abused me and didn't do. We got to be clear that we understand the writ. Whether that judge is duly and rightfully a judge. That's it. That's the writ. That's what you're challenging. Whether that judge is duly and rightfully a judge, not whether he or she did something wrong. No, whether he or she is duly and rightfully a judge. That's the writ. That's the purpose of the writ.
Yes, Abdullah. Yeah. Only reason why I addressed the Abdullah about that conception by the United States Parcel as we go along, Abdullah, all this Quo Warranto bringing down all the authority. This is drop all the bad concepts. Make it clear. I see me Abdullah talk about this. Abdullah brought to my attention Shem. Article 1 is everything. I said, Abdullah, right. What's this to make an argument beyond Article 1? You can't. You got to go look back to Article 1. You can't look at the Constitution. You got to look at Article 1. That's it. You can't go nowhere else.
Article 1 of the Definitive Peace Treaty, Article 1 of the 1783 Definitive Peace Treaty between Great Britain and the United States that ended the Revolutionary War. Just want to be clear when you say Article 1.
Yes. And also, to add to that, under the Act of Algiers, the European powers made it clear that the United States cannot interfere with any questions of law dealing with European affairs. That means the United States is stripped. Once the United States is stripped, any legislative act that gets to the courts, they are stripped. Because the legislative power don't have it, executive power don't have it, the judiciary don't have it, the whole government don't have it. Therefore, when you can't make decisions on European questions of law affairs, Moore's law first dealing with the Moors, the first European affairs. 1600, 1700, 1500 treaties. They're European affairs dealing with the Moors. You can't just come up and make new legislation. You're not. So the Act Algiers knock them out the box. They can't do it. So if you do the Quo Warranto, I'm just saying when we do it, we haven't set the proper way for the government. Go ahead, Amanda. Try to carry on. Carry on so you can clear this up.
4, Article 6 of the Constitution of, I think I was there. And the judges in every state shall be bound thereby anything in the Constitution or laws of any state to the contrary notwithstanding. The senators and representatives before mentioned, and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no other religious test shall ever be required as a qualification to any office or public trust under the United States. Facts. 5, the state agencies, departments, offices, and court, as an elected or appointed body, are usurping authority that is not delegated to the state citizens elected or appointed as representatives, officers, and officials of these agencies, departments, offices, and courts. 6, on blank day, the district attorney and/or police officer assumed jurisdiction over me without taking into account my Moorish government certified issued nationality identification documents. On blank day, police officer so-and-so for the state of Pennsylvania filed an affidavit of probable cause and criminal complaint to prosecute me, a Moroccan national of the Moorish government. The matter is entitled Commonwealth of Pennsylvania versus Jaffers Moody. 8, a hearing on the matter was held on this date or scheduled to be heard on this date before the Chief District Court judged so-and-so and de facto findings of fact, conclusions of law, and orders granting district attorney so-and-so authority to proceed. The court ordered, among other things, its core functions of state elected or appointed officers of the government that are operating in a de facto capacity, that each state agency, official, county, and municipal entity does not have the delegation of authority to determine any civil or criminal dispute between a Moorish national and citizens of the state or United States. Moorish-Moroccan government treaties claim pursuant to the Supremacy Clause in the Constitution of the de jure United States of North America in the Moroccan and British Dominion and Realm. 9, the allegations of the foregoing paragraphs are incorporated in their entirety herein by reference. 10, the court has jurisdiction over this petition and should grant the writ of Quo Warranto to the petitioner, a national of the United Republic of Morocco or the Moorish government state. An argument, prayer for relief. The petitioner seeks 2 forms of relief from the court. First, for the foregoing reasons, and as argued below in the memorandum of law, the petition for writ of Quo Warranto should be granted and the requested writ of Quo Warranto should be issued. Second, for the foregoing reasons, the court should issue a judgment against the state of Pennsylvania, awarding all litigation costs, including attorney's fees, to the petitioner. Memorandum of law. The Moorish consul, sheik or sheikess, make the following arguments in support of the petition for issuance of a writ of quo warranto. Analysis. It shall be noted at the outset in this situation before the court is that the substantial issue in this case concerns the effect of the Moorish-Moroccan treaties violation on the jurisdiction of the state of origin in the United States of North America over the self-executed treaties protecting indigenous aboriginal Moorish-Moroccan nationals of a state within the Moroccan Empire and British realm pursuant to the 1856 treaty between Great Britain and Morocco. This question involves the complex relationship between domestic and international law. This must be addressed as a very important issue when pertaining to indigenous aboriginal, Moorish or Moroccan nationals living in their own lands, waters, and airspace among her British and English subjects, colonies, and corporate subsidiaries, such as the United States of North America and District of Columbia. The Moorish consul, sheik or sheikess, has examined the applicable Moorish-Moroccan treaties provisions to establish that they were indeed ignored and breached. The treaties of concern are the Treaty of Peace and Friendship between His Imperial Majesty, Emperor of Morocco, and the de jure United States of North America of 1787 on the jurisdictional territories and high seas, ratified, signed, and autographed by the United States Congress and President of the United States of North America on this date, these dates, and further the Treaty of Peace and Friendship between the Bey and subjects of Tripoli and the de jure United States of North America of 1796 makes it factually clear on the jurisdictional territories and high seas ratified and signed and autographed by the United States Congress and President of the United States of North America on these dates. And further, the General Act of Algeciras entered into force on this date in Article 123. It's written and says all treaties, conventions, and arrangements of the signatory powers with Morocco remain in force. It is understood, however, that in case of conflict between their provisions and those of the present General Act, the stipulations of the latter shall prevail. Further, the right of protection in Morocco entered into force on this date. In Article 1, it's written and says conditions under which the protection may be conceded are those established in the British and Spanish treaties with the government of Morocco. And further, in Article 5, that the government of Morocco recognizes the right of ministers charged d'affaires and other representatives, which is granted to them by treaties, to select the persons whom they employ, either in their own service or that of their governments, unless such persons shall be sheiks or other employees of the government of Morocco, such as soldiers of the line or of the cavalry, in addition to the magazinias in command of their guard. In like manner, they shall not be permitted to employ any subject of Morocco who is under prosecution. These treaties set forth principles of international law governing the relations of the ratifying states with respect to territorial jurisdiction, to decided civil and criminal disputes in Morocco dominion and British, France, Spanish jurisdictional political zones, including those waters adjacent to a Moorish Moroccan and British, France, and Spanish states coast in Northwest, Central, and South Morocco, Africa, or America, within the Western Hemisphere, that subject to its sovereignty and to the land of and high seas, those waters lying seaward of the territorial lands, seas, and subject to the sovereignty territories of the Moorish government, the British, France, and Spanish territories and political zones. U.S. Supreme Court, Newman versus United States ex rel, Frizzell, 238 U.S. 537, 1915 case. Number 813, argued April 13th, 1915, decided June 21st, 1915, 238 U.S. 537.
Right. That's it.
All right, we have, we got 20 minutes with Shem. We got an hour and 20 minutes for the class, but Shem will be leaving at 9 and then I'll come on, do my thing.
So any questions?
So
For
we got
sure?
20 minutes. 20 minutes,
All right.
questions, comments, criticism. We don't know what we're talking about, you know. Now you gotta show evidence that we don't, not that statement doesn't mean anything.
Yeah, I did want to mention that, you know, a lot of Moors think that, or have been ingrained in Moors that because of the article, what is that, 6 in the United States Constitution, about the treaties, are the law of the land because of the United States. You know, that's what they think, you know, because the United States Constitution says so, but that's not so. So I just wanted to point that out.
That's an excellent point, Terrence. That's an excellent point, and but also has been misrepresented that the only way to force in order to force the treaty is force through the United States Constitution. You have to force it through Article 6. You know, right?
Mm-hmm.
So it's misconceptions. I mean, the treaties aren't the law of the land because the United States says they are the law of the land. I mean, there are pre-existing obligations. The definitive peace treaty between the United States and Great Britain is not binding on the United States because they put it in Article 6.
Mm-hmm.
This is a pre-existing contract, pre-existing obligations. All debts, engagements enter into before this adoption of this Constitution shall be valid against this Constitution, against the Confederation. Right there.
Mm-hmm.
I mean,
And so there needs to be that other body to enforce it.
So
The other
therefore,
body and party to the contract.
Yes.
yes.
So either this misconcept of enforce the Constitution, when you enforce the Constitution, you're forcing the treaty. When you're enforcing the Constitution, you're enforcing the treaty. That's a misconception.
Absolutely.
Like, all right. Where's that? Show me. Where's that written? Show me in a Moorish treaty. Show me the treaty that's where that's written.
In any treaty.
Any treaty, in order to you force the Constitution, you got to force. In order to force a treaty between China and the United States, you got to enforce the Constitution. In order to force the 1850 treaty between the Swiss Confederation and the United States, you got to enforce the Constitution. Let's go to Hauenstein. You're not going to say Abdullah said. Hauenstein versus Lynham. Hauenstein versus Lynham doesn't read that. Let's look at these. In order to force the Constitution, in order to force the treaty, you have to enforce the Constitution. Like, where's that coming from? Where's that?
Touch on Hauenstein versus Lynham. Just yes. So.
Yes, let me just not mention it. Yes.
Just put the case out.
On August 24th, and August 31st, on the Moroccan Post Media YouTube page, Moorish Treaty Protection and Consular Relations, August 24th class and August 31st class. We have Hauenstein versus Lynham. Amanda read. She read excerpt of the case. Hauenstein versus Lynham. All right. Solomon Hauenstein had purchased 3 properties in Virginia. And Virginia had sold his properties. He had transitioned. Virginia had sold his properties and kept the proceeds and said that
Not a debt.
He
A
didn't have,
egg
he didn't have rights to the proceeds of the sale.
should not be here. Why does he have Aston?
Well, excuse me, what's going on? He didn't have rights to the proceeds of the sale. His nephew and niece had sued to recover the proceeds from the sale. First, before it had to be determined whether Hausenstein had ever renounced his allegiance to Switzerland. Once it was determined that Solomon Hausenstein, never renounced his allegiance to Switzerland, now that determined what law applied. The treaty, the 1850 treaty between the Swiss Confederation and the United States applied because Hausenstein was a Swiss citizen. He had never renounced his allegiance and his Swiss citizenship to Switzerland. Article 5 of the treaty between the Swiss Confederation and the United States, 1850, allowed Hausenstein's relatives to recover the proceeds from the sale, ruling that Virginia statute to be in violation of the treaty. Nowhere in that case, nor in that treaty between Switzerland, Swiss Confederation, and United States that you have to force, in order to force this treaty, you got to force the Constitution. You got to force the Constitution in order to force this treaty. They don't even mention any acts, statute of large. The only part of the treaty that's the Constitution is mentioned is Article 6, because the United States Supreme Court made a lengthy discussion, writing on Article 6, because Virginia had violated the treaty. Virginia was stretching the muscles that they can, that Hausenstein didn't have a right. So if a state can alone violate this treaty, and so it's a lengthy discussion. We read that article, August 24th and August 31st class. Moroccan Post Media YouTube page. Please look at that. If you haven't seen it, if you have, review that. All right, we go heavy into treaty studies, and also I go into from 9 to 10. I think also throughout the 8 September, we read the 15-page excerpt.
Yes.
The 15-page excerpt of the United States counter memorial in the 1952 case between France and the United States, where they're in that 15-page excerpt that I took out of 600 pages, chapter 9 of Moors and Masonry Part 2. That 15-page excerpt is in chapter 9 of Moors and Masonry Part 2. And part of that 15-page excerpt are capitulatory or treaty clauses, capitulatory extraterritorial consular jurisdiction treaty clauses of treaties dating back throughout the 16, 17, 1800s. Let me explain the difference. And since I said a term, I got to explain. Capitulatory is the older term that was used. The more modern, more recent term is extraterritoriality. But capitulatory was the older term back in the 1200s, 1300s, 14 and 1500s. So that's why you'll see I'll have capitulatory / extraterritorial consular jurisdiction. There's a difference between capitulatory / extraterritorial consular jurisdiction and consular jurisdiction. In in extraterritorial consular jurisdiction, a Moorish consul would have jurisdiction over both criminal and civil matter, or a consul, all right, would have jurisdiction of both criminal and civil matters. In consular jurisdiction is only civil matters. So you need to understand that as we preparing out to be consuls and ambassadors and so forth, and international jurists and so forth. You need to understand the distinction between those terms.
All right, thanks, Abdullah, for going into that.
Mhm.
So in real short, so since he did not renounce his citizenship or allegiance to Switzerland, they had to apply what law applied to. So it was the treaty in the United States Constitution. So therefore, they did not have to enforce the Constitution to do anything with that treaty.
Father, that's utterly ridiculous, man.
Yes,
It's utterly ridiculous.
So therefore, if you are a citizen of the United States, then you use the Constitution. Then they would use the Constitution, but since he was not a citizen of the United States, he did not renounce his citizenship. So they had to go with the international document, which was the treaty.
Yes, once his heirs, once the kinsmanship heirs, descent, made a claim, the Hausenstein, they're the children of Hausenstein, and he was a French under, I believe it was the French government. Was
No,
Switzerland. Switzerland. Wants to see, remember, once they made a claim that they are the descent of Hausenstein, which is a French, which is a Swiss government national. So you see what's going on now. Pedigree. This is called pedigree now. We do a pedigree now. Consanguinity. They claim the consanguinity of French as a Switzerland.
Yes.
Swiss, as a Swiss national. So by them claiming that, the Moors, we claiming the consanguinity as Moors. So give us the same right to make a claim on behalf of what? Our ancestors. Yes.
Absolutely. Thank you. I just wanted to bring that out.
Yes. Go ahead, Amanda.
No. There's no more reading.
We're done, right, Amanda?
Yes, we're done with the reading.
Okay, we're done. Okay.
We are on the Ask Shem questions time.
Okay. Let's go.
Anybody have any questions for Shem? 10 minutes. Well, 7 minutes. I'm sorry.
Islam.
All right. You have the floor,
Right.
brother.
Okay. I, like you, have been teaching the Moors signed the Constitution also. However, I'm up in the air, but maybe you can dispel something for me, and then that way I can kind of reason it out in my mind, in my own mind. Brother Hakeem Bey, during one of his videos, showed the bays and eels fezzes in the Masonic Museum in Washington, D.C. He went down into I think he mentioned it was the grotto room or something to that effect. Anyway, he went in the room and he showed these pictures of fezzes with bays and eels on the fezzes, the names of bays and eels on the fezzes. So there is some other information also. CM Bay wrote a preamble, which a lot of people was not exposed to. They understood, or they read the Zodiac Constitution, but they didn't have access to the preamble. In that preamble, he said that the federal government is the Moorish government. Now, let me finish. I'm setting this up. Also, the prophet said that there was a constitution in his Moorish literature. He said that there was a constitution written for all free people of the earth. Now, so here you got a reference to a constitution with the prophet. And now you got a reference with CM Bay saying that the Moorish federal government is the federal government. So along with the picture of the fezzes, kind of dispel what's going on there.
All right, let me take this over, Shem. I got this. All right, we have a book that we it's called Ask the Right Question, Asking the Right Question, a guide to critical thinking. Chapters 7 and 8 are the evidence section. That's the evidence chapters, chapters 7 and 8 of the book that we've been pushing for the past month now. Asking the Right Question, a guide to critical thinking, book that will push, that'll be part of this, that'll be part of the Moroccan Post School of Government International Law. That'll be a course in this school. We'll use that book as a course. And I'll be so for the next year, we'll be getting heavy into that book. So I want y'all to listen to what he's saying. I want y'all to hear what he's saying, and I want y'all weigh as he was talking. I trust y'all was asking your question. Is that evidence? Did the brother present evidence to support his claim?
Absolutely.
Is a statement.
Mhm.
A statement written by Juali. Evidence is a statement written by CM Bay. Evidence. Please, this is asking the right question. We got to rise to this. Asking the right question, a guide to critical thinking. What is evidence? Did the brother present evidence to support his claim? Is a statement evidence? Yannick, when we were on 2 weeks ago, Tuesday, 15 days ago, Yannick and I had a discussion. I was in Dunkin' Donuts. Yannick and I talk every day. And Yannick made a claim that the Ottoman Empire, Yannick made the claim that the Ottoman Empire controlled what was it, Yannick? Florida, right? Right?
New Smyrna.
Smyrna, all right? So I said, Yannick, produce the evidence. Yannick went to a book and read something from an author from a book, particular book. I can't recall the name of the book, or I don't think he told me the name of the book, but he read a statement. And I said, Yannick, that's not evidence. What would be evidence would be a survey map. A survey map with the authorized by a bey or the pasha of the Ottoman Empire. And that is on the survey map, or it's a delegation of authority by a pasha delegating authority to a survey company. All right, and you have the survey map. A statement such that is not evidence. So, brother, you did not give us evidence. You gave us a statement by Shem Bay and by Juali. That's not evidence. Let's talk about the fezzes. the ancient Arabic order of the nobles of the mystic shrine, now known as Shriners International. There are 200 shrine temples in the world. Those fezzes, the Europeans claimed, took our fezzes, our Moorish fezzes. They're using our Moorish names. The names that are on the fezzes are the Moorish names that are on the fezzes worn by the ancient Arabic order, members of the ancient Arabic order of the nobles of the Mystic Shrine, now called Shriners International, are names that, Moorish names that these Albions use for their Moorish, for their temples. Those are the names of those are Moorish names that the Albions use for their Moorish temples. There's 206 of them. I mean, there's Moorish names. You're talking about, let's go back and go back 1,000 years. Those are Moorish names that European, but that's not evidence that Moors are part and parcel. Those are Moorish names. You see the pure divan, the divan, the Europeans took the name of our government structure, divan, and you see D-I-V-A-N. You'll see divan in the treaties that I have in Moors and Masonry Part 1. You'll see the word divan, D-I-V-A-N, in the treaties between the Moroccan Empire and Great Britain, the Moroccan Empire and France, Algiers in France, Algiers in England. You'll see the word divan in those treaties. They're in Moors and Masonry Part 1. That European, the ancient Arabic order of the nobles Mr. Shrine, those Europeans took divan. Let me explain what divan is. Divan is the cabinet, the royal cabinet of the emperor, what became what would be what the secretary, the minister of finance, the minister of defense, the minister of education. That encompasses the divan. The Shriners took that. They're claiming that, and that is the structure of their shrine organization. I just had to, since you brought it up, I had to make sure, because we're gonna have people watching this. I don't want to miss, I do not want to have any miss pieces. All right, I can break it down. I can break it down.
I think you proved my point, brother.
For 25 years.
I think you proved my point.
What's your point? What's your claim? What's your claim? My bad. What's your claim? What's your claim?
Okay, all right. So, this is what I was taught, and this is what I.
All right, give me your claim.
Okay, all right. I'm ready to give it to you. I'm just setting it up. That the
no, don't set it up. No, brother. Don't set it up. Please, brother. No, brother. Let me stop you.
Okay, I'll give you the claim.
No, just give me the claim. Don't set it up. Just give me the claim. Don't set it up. Just give me the claim.
Okay. One of the. Okay. The claim.
You gotta learn to do this, brother. I know I'm hard. I know I'm hard.
No, that's fine. No, that's fine.
I'm hard. I'm hard.
And I mean those just no respect. I'm trying to
no,
really.
But I'm doing this because brother. We have to learn to do this. We have to learn. We have to learn. You don't get to it. State your claim. Don't set it up. State your claim. I can help you. We have to learn how to do this.
Okay.
We must learn how to do this, brother.
Okay. All right. This is what I was taught, and this is my claim of what I was taught. That the Moors, when the Europeans came.
No, brother, stop.
This is my claim.
No, but don't.
This is my claim, brother.
No, but that's not a claim. Just don't explain. A claim is not explaining. That's not a claim.
Okay.
A claim is a statement. It's not explaining. Okay. It's a statement. Yeah, and you setting it up. Don't set it up. It's the statement. Give me a statement. Claim.
The claim is the Moors taught the Europeans civilization how to run the government. They,
All right, that's true.
all right? And
That's true.
they, when they got their feathers from the Moors, they became Moors themselves. That's my claim.
All right. Now, there's no evidence. All right, you didn't present evidence to support that. That's the second statement. All right, that's not the first statement.
All right.
There's a preponderance of evidence, so we good. We good. The second statement, the second claim is that when the Europeans, all right, got the feathers, they became Moors themselves. Where there was produced the evidence to support that claim. Feathers being in the feathers being at the George Washington National Memorial Room. That's the Shriners Room. The Shriners Room at the George Washington Masonic National Memorial Museum.
Right.
The Shriners, the ancient Arabic orders of the nobles of Mr. Shrine,
There you go.
established that in 1871, now called Shriners International. They're claiming our feathers. Where's the evidence that the Moors gave them the feathers? I am hard for a reason, because I love our people. I want us to rise, bro. We're going to rise through education. That's the only way. The only way to rise is through education. The only way we're going to rise through education.
And also, someone giving someone a fez does not make you a Moor. Fezzes does not make
Go ahead, T.
Moor.
Go ahead, T.
All right. Okay.
Your bloodline.
Now, hold on, T. I want you to finish, T. For remember, we got listeners, people who know stuff. Remember, people going to watch it who don't know anything. So I need you to explain to the listeners, those who'll be watching this, the hundreds or maybe a couple thousand, since giving someone a fez doesn't make one and more. Explain to the audience what makes one or more.
It's your bloodline, your pedigree, your descent. So
You ever heard the story of Yaqub? See, what I'm saying is it goes back, it requires a lot of explanation, because by the preponderance of the evidence I can prove. But I don't want to belabor it.
No, brother.
Okay. I don't want to belabor it, brother.
Yeah, evidence. It's just present evidence. It's not evidence.
All
No
right. That's
belaboring.
good.
It's understanding what evidence is, not belaboring.
I said preponderance.
All right. We're gonna move on.
I'm just
All
saying.
right, Brother King, let's finish up your last question, because we have already cut into my time. Go ahead, Brother King.
Okay, my question is, a lot of Moors believe in this commercial banking system that they are sovereign and that they are bankers. So I want you to answer that in accordance to this commercial banking system that the United States have set up. They say that they are bankers, and they're saying that they have a right to do banking without the provisional government there giving them guidance and the structure to operate and do business with the United States. I need you guys.
Let me break this down.
All right, no, Shem, you're gonna have to stay a little longer.
I'm gonna break it down. See, a judge. Go ahead.
You want to stay a little longer? It's going to take you about 10 minutes to answer that. Go ahead.
Yes.
I want you to go into detail.
A judge is delegated authority by the parliament. Now, actually, he got a gavel in his hand. He also is what you call a clerk, do book entry. So in banking, you deal with book entry. Judge is a person to book entries on securities and claims of goods. So he's in the court. When he's in the court, he's operating a dispute on goods or merchandise, which is your property, which is your estate. So he's considered a banker. Why? Because he got the gavel. He making decisions and book entries on the adjudicating a decision on the collateral that's in front of him. He got power to speak on the collateral. Now let me explain what I mean amnesty and mertile law. You come into the courtroom with a constitutional claim, you bring it under a mertile law, man, a contract. The Constitution is violated, your rights is violated. It's mertile law. Amnesty means that you come into that courtroom as a citizen of that state. So you deal with mertile contracts. The Constitution become a contract now that the citizen is looking to enforce in the courtroom. We give the judge the power to what? To litigate. He enters into a journal book entry. The judge give adjudication on the case or monetary rewards for 100,000, 600,000. The judge make determination against one to have their estate froze, to have what you call garnishment of the accounts, and every judge keep a book entry on what is before him. So what gives the judge power to speak is what? The same thing when you go to a bank. You go to the bank to make a deposit. When you file a petition, a motion in the court, you're making a deposit. What are you depositing? What are you depositing? See, you gotta realize what's going on here. In amnesty law, mertile contract, you're depositing yourself in that depository. I mean, you taking a petition, it's like walking to the bank making a deposit. And you want the bank to open up an account. The judge got to open up what? He opened up a dispute on the floor about you. You mean your body, your commodity, your goods, based on what? Your name, the asset name, the birth certificate name. So the judge is making book. He got a clerk. He do book entries the same day banks do. The judge make decisions. He open an account for you. What do you mean? I go to the bank, open an account, Shem. Don't make adjudications for me. Yes, they do. The bank do it every day. Every time you make a deposit, the bank is doing book entries on you and making adjudication. I mean, they allow you to walk into a bank. The only way the judge can hear, the only way the banker can hear, can sit down to business with you, and you got to produce what? An ID and say you're a citizen, and you got a right to open an account. The banker asks you for all kinds of questions. Let me see your ID, proof of ID. Number one, when you go in the courtroom, the judge will prove you the person, the party that bring the claim. Now you come in with a banking contract. Hear me out. Very important. And the banks are obligated to operate on what? On the laws of that state, what gives them a license to do banking there. Yes, it is. So what makes the Moors, the conscious Moors, who been on the wrong concept, think that they got sovereignty to the courts because the judge, the banker. No. Judge, that's running business. All this is running amnesty and mertile business. It's all this. There's no sovereignty in the court at all. Look back at any old ancient government. Show me any ancient government where people got sovereignty to a court. They don't. They got sovereignty to the government. That's a sovereignty come to your government. The community are people in the government who have the inherent power elected by the people or are operating on a power of monarchy. That's it. So the reason why Moors think that they got sovereign power under UCC law, let me address this now. First of all, the UCC law is written by the legislators of Congress. So in order for you, there's nothing in that act saying that you got any sovereignty. When you follow UCC 1 as a secure party creditor, that you're sovereign to the land, you're still a United States citizen. When you go to court, you go for a judge say, I'm a secure party creditor. Judge say, now basically you're not a secure party creditor. Why? Because you have the money, you have no collateral, not over yourself. And now that the money system that you're using is not yours, it's theirs. So how you be a secure party creditor when you owe an obligation to abide by all the laws of the legislative branch when you're dealing with that money. That means you can't do nothing with that money unless the government tell you how to do it. And when the dispute arises, you go into the courts. Based on the maritime contract was violated. That means when you sign a contract with a bank, that's a maritime contract, a merchant contract. So when that contract is breached, it got to be breached on what? It got to be breached on the obligation of the sovereign power, which is the Constitution of the states. So when it breached, you come in complaining that the agency violates your rights under the Constitution, under Article so-and-so, or the Second Amendment, whatever it is. You argue, reason with the courts that right been violated in that by the breach of that contract, the maritime contract. So you're not sovereign. A sovereign is someone that absolutely have the answers to no one. When they sign a contract, they control everything from start to finish. there's no stipulation, obligation against a sovereign. A sovereign owes nobody any debt. So you say you're sovereign, you got to have first of all, you got to be a citizen of a free society. You're not representing a free society. This is a freedom. So the answer why Moors think that follow UCC 1 and they're sovereign and doing a security agreement, because for a lot of years the Abdullah said misconcept is they cannot go to a document and read a document and states that anyone follow UCC 1 have exemption and immunity from the laws of the United States. If they follow that, it doesn't say that. So where's the evidence at? Where's the language at? Where's the treaty at to say that the United States agree with Moors that you follow a commercial instrument, you automatically got exemption. The only thing in the treaty say that you were talking commercial obligation, the only thing in the treaty say is passport, papers, identity, and flag. A sign, it's a sign. That's your creditor status, your government vessel, your government. Under protection of that government, the government is the creditor. You become a creditor based on the government status. The government got to have a status as a creditor first. Then you already automatically got that status because you get a government that inherent power to have that status. Now, if it's an empire, a queen or emperor, the inherent status still comes from the people because the emperor descends from some house or the king or queen come out of a house. So you see, in order to say you're sovereign, you got to first be sovereign in your mind, then you got to, as a community, as a whole, then you got to form a constitution to protect yourself. That's sovereignty. So you can't base sovereignty on UCC 1 filing because if you go through the language of UCC filing, the treaty does not say that all Moors have a right to protection if they file with the foreign state a commercial agreement to protect their sovereignty. The treaty doesn't say that. Neither the United States states that. So when somebody make that statement, just go through the treaty. What is that? There's nothing in the Act of Algiers. There's nothing in the Act of Protect Morocco 1880. Where's this coming at? A private statement made by Moors to justify himself in a long run of misconceptions. Now nobody would claim it's wrong. Nobody would claim it's wrong. For a long time, we misguided and it's wrong. That's all we got to do. Be humble and say it's wrong. So a judge is the one to do it. Judge is the one to make adjudications. The clerk of the court is the same one to make book entries. And by the way, they bond the case. You are the collateral when you go in the courtroom. They bond the case through your existence and as their collateral, surety. So they have the same power that a banker got because you in there making a claim in a courtroom. Therefore, the judge got power to do what? To deposit your petition or dismiss your petition, period. You understand? I mean, he got power to reject your deposit or receive your deposit. You understand?
I get it. It's not for me. It's people running around charging membership $1,000 to $500 to be a part of their banking association and saying that they got foreign sovereign immunity, and I'm telling them that's a fallacy.
Yes, because you know why? It's not written in the treaties. It's not written in any legislative act of the treaties or any more legislative act or inside the United States legislative body. When they created the Uniform Commercial Code, it does not read in there, anybody follows security agreement, UCC 1 is exempt, it has absolute immunity exemption from the government. Doesn't say that. If the language is not there, then how you solve it? Anything else?
Right.
That's it. I just wanted you to clear up that because I got Moors telling me that they're bankers, they're doing this, and I just wanted it to be on account where they understand that they think they have these rights and that they don't have.
Yes. Okay, I'm about to go. I appreciate y'all. Thank you very much for the class. Yeah, thank y'all, all of y'all. I appreciate y'all, Islam.
It's love, it's love.
Oh, brother.
All right, peace.
All right, peace, brother.
All right,
Peace, peace, Islam.
peace.
It's good. It was good, man. He did a wonderful job. My man.
All right.
Good job, fellas, good job.
Man, great. Wow. We have Amanda. You up to doing more
right.
reading?
Yeah.
Yeah.
I hope you drink water. All right.
I know,
So,
drink some water, Amanda.
all right. So, so we're
Well,
gonna
she
go ahead.
knew she knew she would be doing this. I was
Yes,
trying to
so
get
she'll read.
somebody else to read the other stuff so she could.
All right. So we're gonna kick in to gear with this
Yeah.
here, and then we're gonna actually explain it next classes.
Yes. So let me.
we have
Yes,
about-
we're going. Amanda's going to read this whole thing. So she's going to read everything so that it's on the recording. The next class, the next Wednesday class, and also the next Sunday presentation on Moroccan Post on Come TV. I'm going to do the 3 hours the next Wednesday class. So it's going to be my show, the next all 3 hours. We're going to read. We're going to go through this whole document. We're going to go question by question. I'm going to answer the questions. All right. But today I only got 40 minutes. Amanda's going to read everything. So it's on the recording. I want to get people to get their juices rolling. All right. That's what we're going to do. So if I have time, we should have some time after she reads this. And I'm going to present our case.
All right.
Don't
You see
forget
it?
about the sovereignty of the
Excuse me, Amanda. I mean, they also state that this is an excerpt from my book coming out in the fall. Now, Moors and Masonry Part 2. This is the definitive peace treaty between Great Britain and United States as the ruling authority for the United States. It's the 1783 definitive peace treaty between Great Britain and United States as the ruling authority for the United States. This is the excerpt. On Sunday, not this past Sunday, was that was it
Not I think
this past Sunday? Sunday before last. Yannick had asked me. I was in Starbucks and I was about to work on Moors and Masonry. We were in Dunkin' Donuts and I'm talking to him and we were on the phone for a couple hours and I was in Starbucks and I was about to take out my laptop to work on my book, Moors and Masonry, finish up Moors and Masonry Part 2. And Yannick asked me, Abdullah, do you have, can you give me 10 questions related to this stuff, related to the definitive 1783 definitive peace treaty between Great Britain and the United States? I said, well, I don't think I got 10 in me, brother. I think I can give you about 3. So I ended up coming up with 12 before we hung up. And then we ended up hanging up about 1 o'clock. And I said, well, Starbucks closed at 2 o'clock. There's no need for me to take out. I'm going to have an hour. So let me just stay on to generate some more questions. I ended up generating 8 additional questions, right? Then I went home and chilled and I generated 6 more questions. Here you got 27 questions right here. All right. So I wanted to let Yannick gives Yannick some, credit for this. Because there's no way that I would even think about, because I'm working on Moors Masonry Part 2. So I'm not thinking about coming up with 10 questions. And I only did that because he said that this would help him out, that those 10, that if I gave him 10 questions, that would help his, better understanding. And then of course, Yannick being Yannick, he's not only thinking about himself. Yannick never thinks about himself only. He never thinks about himself only. So he's always thinking about the people. Well, we can, Abdullah, I'm gonna do a question of the day and to put the question of the day on my Instagram. And then I say, yeah, do the question of the day, and then we give the question later on the day. So he's always thinking about, it's not just, well, I'm gonna keep the 10 questions myself. Yannick doesn't think like that. Right? So I appreciate you, Yannick. My man.
All right, appreciate you, brother. All right, let's get into it.
All right,
Islam.
so I just wanted to, give that background.
All
Let's
right.
get into it.
Don't forget about the sovereignty of the English British Crown. Note, The English-British Crown extended English-British sovereignty to the 13 original states through Article 1 of the 1783 Definitive Peace Treaty between Great Britain and the United States. Note, the 13 original states extended the British sovereignty extended to them through Article 1 of the 1783 Definitive Peace Treaty between Great Britain and the United States to the people of the United States. Hence, the phrase, quote, "We the people of the United States," in the preamble to the United States Constitution. In the Articles of Confederation, United States of America is known as the style name. The style name of this, quote, "The style name of this confederacy shall be the United States of America." Purpose of the questions. The following questions are presented to the public to clarify with solid documentary evidence and critical thinking the misinformation and misconceptions that 1, the Moors are part and parcel or partial of the United States. 2, the Moors are, quote, "We the people," in the preamble to the United States Constitution. 3, 35 Moors were part of drafting the United States Constitution at the Constitutional Convention in 1787. 4, the Moors are the founders of the United States. 5, the United States Constitution is the Moorish Constitution. By showing evidence that the original foundational authority for the United States is derived from Article 1 of the 1783 Definitive Peace Treaty between Great Britain and the United States. Note, some conscious Moors have claimed for over 30 years that "we the people" in the preamble to the United States Constitution denotes the Moors and Moorish sovereignty. The statement, quote, "do ordain this Constitution for the United States of America." Some conscious Moors have claimed for over 30 years that this statement means the Moors are delegating authority to the Albions to function as a national government. Hence, Moors claiming the United States Constitution is the Moorish Constitution and the United States government is the Moorish government. Questions. 1, did the Revolutionary War between Great Britain and the United States extinguish pre-Revolutionary War contracts that were granted to British subjects by the British Crown during the 1600s and 1700s in British colonies? 2, does the United States derive its original foundational authority to operate in the territorial boundaries outlined in the 13 English-British colonies charters from Article 1 of the 1783 Definitive Peace Treaty between Great Britain and the United States, or does the United States' original foundational authority to operate in the territorial boundaries outlined in the 13 English-British colonies charters derived from the United States Constitution drafted in 1787? 3, do the original 13 states derive their authority to operate in the territorial boundaries outlined in the 13 English-British charters from their states' constitutions of 1776, Declaration of Independence of 1776, the Articles of Confederation, more recent states' constitutions, or the United States Constitution drafted in 1787? 4, do the original 13 states derive their foundational authority to operate in the territorial boundaries outlined in the 13 British English charters from Article 1 of the 1783 Definitive Peace Treaty between Great Britain and the United States? 5, did the English-British Crown relinquish its territory jurisdictional boundaries outlined in the 13 English-British charters to each of the 13 original states through Article 1 of the Definitive Peace Treaty between Great Britain and the United States, or to the United States? 6, does the Declaration of Independence of 1776 mark the independence for the United States? 7, what is a landmark case in the United States Supreme Court that states that pre-Revolutionary War rights granted to British subjects before the war are protected in the 1783 Definitive Peace Treaty between Great Britain and the United States? 8, why don't the original 13 states operate under the Articles of Confederacy? 9, does the United States have the authority to dissolve the 1783 definitive peace treaty? 10, why did the United States issue a commemorative stamp in 1983 commemorating ratification of the 1783 definitive peace treaty between Great Britain and the United States? 11, why are there no annual ceremonies or national holidays celebrating the ratification of the 1783 definitive peace treaty between Great Britain and the United States? 12, do the 13 original states who derive their original foundational authority to operate in the territorial boundaries outlined in the 13 English-British charters and relinquished to them by the English-British Crown through Article 1 of the definitive peace treaty between Great Britain and the United States, have the authority to restore the Moorish land rights to the Moors? 13, do the 13 English-British colonies chartered under the sovereignty of the English-British Crown become the 13 original states? 14, by what authority did the royal governors in the royal colonies, the lord proprietors in the proprietary colonies, and the companies in the corporate colonies have to separate from the English-British Crown and declare independence from the English-British Crown? 15, did the 13 English-British colonies, proprietary colonies, royal colonies, company colonies, chartered under the sovereignty of the English-British Crown, declare independence from the British Crown in 1776? 16, did the 13 English-British colonies, proprietary colonies, royal colonies, company colonies, chartered under the sovereignty of the English-British Crown, establish the United States in 1776? 17, did the English-British Crown relinquish her jurisdiction of the territorial boundaries to the lands outlined in each of the 13 British colonies' charters to each of the individual states in Article 1 of the 1783 definitive peace treaty between Great Britain and the United States, or in the Articles of Confederation of 1781? 18, did the Revolutionary War between Great Britain and the United States affect the capacity of private individuals, British subjects, or of corporations created by the British Crown to hold lands or other properties in the territorial boundaries outlined in the 13 English-British colonies charters? 19, why are the United States citizens not aware that the 1783 definitive peace treaty between Great Britain and the United States marks the independence for the United States? 20, what United States Supreme Court case shows that the 13 original states only divested their rights to the United States during the United States Constitutional Convention in 1787, relinquished to them by the English-British Crown in Article 1 of the 1783 definitive peace treaty, and not surrender their rights to the United States in 1787? 21, why did the English freemen in each of the 13 English-British colonies draft state constitutions and hold state constitutional conventions when the 13 English-British colonies charters already existed? 22, why did the English freemen in each of the 13 English-British colonies not use the colonies' charters chartered under the sovereignty of the English-British Crown as their states' constitutions? 23, does this political act of the freemen convening in constitutional conventions and drafting constitutions mean that the 13 English-British colonies chartered under the sovereignty of the English-British Crown declared independence from the United States? 24, does this political act of the freemen convening in constitutional conventions and drafting constitutions that the 13 English-British colonies chartered under the sovereignty of the English-British Crown became states? 25, does this political act of the freemen convening in constitutional conventions and drafting constitutions mean that the English freemen in the 13 English-British colonies chartered under the sovereignty of the English-British Crown formed separate bodies politic outside of the authority of the colonies chartered colonies charters chartered under the sovereignty of the English British Crown. 26, does this political act of the freemen convening in constitutional conventions and drafting constitutions mean that the 13 political bodies formed outside of the authority of the English British charters chartered under the sovereignty of the English British Crown formed as colonies? 27, does the Commonwealth of Pennsylvania derive its authority to operate in the jurisdiction of the territorial boundaries laid out in the William Penn's Charter, or from the people of the Commonwealth of Pennsylvania and the Constitution of the Commonwealth of Pennsylvania? Note, the 13 English British colonies were created through royal charters, proprietary charters, and company charters chartered under the sovereignty of the English British Crown.
That's it?
No,
Nope. No, we got one more.
nope. The English British colonies, royal colonies, proprietary colonies, and company colonies chartered under the sovereignty of the English British Crown did not become states. Note, the 13 original states are separate political bodies from the royal colonies, proprietary colonies, and company colonies chartered under the sovereignty of the English British Crown. The English freemen and esquires in the English British colonies convened in constitutional conventions and drafted constitutions. These political acts of convening in constitutional conventions and drafting constitutions established separate political bodies from the colonies. Each state was vested with the sovereignty of the English British Crown to operate in the jurisdiction of the territorial boundaries drafted in each of the royal charters, proprietary charters, and company charters chartered under the sovereignty of the English British Crown through the 1783 definitive peace treaty between Great Britain and the United States. We, the people of the United States, is the repository of the collective vested sovereignty of the 13 states derived from the British Crown through Article 1 of the definitive peace treaty of 1783. Each state divested their sovereignty that was derived from the British Crown into the central governing body known as the United States through the principle of federalism. The 13 states convened at the 1787 Constitutional Convention as a League of Confederated States formed under the Articles of Confederation. Each state was represented by delegation, functioning not in their individual capacity, but in their capacity as delegates, having been delegated authority by their states to represent their states. The 1783 definitive peace treaty between Great Britain and the United States is the law of the land and ruling authority for the United States because the 1783 definitive peace treaty grants the states self-determined rights. The states would not be able to occupy the colonies without the 1783 treaty. Anytime the United States enters into any treaty with a foreign country, the treaty has the legislative authority to rule in all the political jurisdictions of all the states. The treaties are res judicata based on the language in the treaties. If January 14th marks the United States independence, then what is the 4th of July?
All right. So we go back to question number 1. We have 15 minutes. So we're gonna use the last 5 minutes to do our our goodbyes and likes and all that. All right, question number 1.
Did
I
the
read
Revolutionary War between Great Britain and the United States extinguish pre-Revolutionary War contracts that were granted to British subjects by the British Crown during the 1600s and 1700s in British colonies?
All right, no, there's a case called Society versus New Haven, 1823, Society of the Gospel of the Propagated Faith versus New Haven. Society of the Gospel of the Propagated Faith was chartered under the sovereignty of the British Crown. In that case, Mr. Webster, the defense attorney for New Haven, made the claim that the society does not have, the society does not have a claim under the charter, because the Revolutionary War extinguished any claims that the society would have under the charter. The United States Supreme Court ruled that the Revolutionary War did not extinguish any pre-Revolutionary War rights. So that case there is in support. So it's very clear. So the answer is no. Number two.
Number two, does the United States derive its original foundational authority to operate in the territorial boundaries outlined in the 13 English British colonies charters from Article 1 of the definitive peace of the 1783 definitive peace treaty between Great Britain and the United States? Or does the United States original foundational authority to operate in the territorial boundaries outlined in the 13 English British colonies charters derived from the United States Constitution drafted in 1787?
The answer is neither. The answer is neither. The answer is neither. Let's go to Article, can you pull up Article 1, the Definitive Peace Treaty? The answer is neither.
Absolutely.
Also People versus Godfrey. So
All
that,
right.
I'm giving, don't give the reference. The answer is neither. Let's go to the Article 1 of the Definitive Peace Treaty. Remember, it says, does the United States, does the United States, does the United States, does the United States.
Wait a minute, where's my definitive peace treaty? Where is it? Where are you? You're right here. All right, here we go. All right, you're up.
Article 1.
His Britannic Majesty acknowledges the said United States, viz., namely New Hampshire, Massachusetts Bay, Rhode Island and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia to be free, sovereign, and independent states, that he treats with them as such, and for himself, his heirs, and his successors, relinquishes all claims to the government propriety and territorial rights of the same and every part thereof.
All right, there's 4 key words. 4 key words. Viz, which is Latin for namely. We have them. We have independent and states. So states is plural. States. Them is a personal pronoun. Objective case, plural. All right. And the namely, so let's look at this construction. Namely, in each of the 13 are named. Let's take it out. Let's take namely. So Amanda, read it without namely. Read it without viz and the 13 states.
His Britannic Majesty acknowledges the said United States to be free, sovereign, and independent states, that he treats with them as such, and for himself, his heirs, and successors, relinquishes all claims to the government propriety and territorial rights of the same and every part thereof.
All right, so we have them. Them is plural. So does the personal pronoun them denote the term United States? Does the personal pronoun them? All right, then we have independent states. Independent states. So you have United States. So does that denote the United States? Independent states. You have them and we have independent states. Let's go to People versus Godfrey. People versus Godfrey, 1819, is a New York State Supreme Court case, 204 years old. A New York State Supreme Court, a landmark case, a state case, a New York State Supreme Court case is a landmark case for 204 years. Let's hit it. Let's go to that section, T, that I read on a Sunday.
All right, here it goes. Coming up.
Section that I read on Sunday. So Amanda's gonna read that section.
All right, give me 1 second. I just lost it. So here we go. I'm gonna bring it right back up.
And I read that section very fast because we had 2 minutes. I had 2 minutes to read it. So we're gonna slow it down.
All right, I got you.
Got some time. Mhm.
All right, I'm gonna blow it up for you real quick.
All right, so this is a landmark case. Never went to United States Supreme, never went to the Supreme Court. I want to explain, understand why. You understand why did this state Supreme Court never touch the federal Supreme Court?
All right.
All right, let's go right to that section.
All right. Now I'm looking for my document here. Hold on. Oh, here we are. Wait a minute. Where did you go?
I can't see it, so I don't know what this.
You can't see it?
No, it's too small.
Can everyone else see it? Show of hands. Yes, I see it. Amanda,
All
can
right.
you hear me?
Yeah, I can
Amanda
see it.
All right. Wonderful, wonderful.
All right, good. It doesn't matter. I don't have to see it. I'm gonna hear it. I mean, I know it. I don't.
That's fine. I just want to make sure everybody can see it. Just want to
All
make
right, yeah, I don't need to see it.
sure. All right. Amanda?
That
Which-
section, go to that section that I read on Sunday, T.
Here we are.
There you go. All right. It's People versus Godfrey, 1819, New York State Supreme Court case.
Mhm. The highlighted section.
The highlight section, Amanda. Amanda.
I'm sorry,
Yeah,
I was on mute. I'm sorry. We consider it beyond all doubt that the United States acquired no territorial rights to any portion of this state in virtue of the treaties of 1783 and 1794.
Stop there. Go, I want you to go read that again. Just slow it down. Slow it down. Go ahead.
We consider it beyond all doubt that the United States acquired no territorial rights to any portion of this state in virtue of the treaties of 1783 and 1794. Neither of those treaties contain any words of grant to the United States as such, nor should we have submitted to accept as a grant what had already been acquired by our arms and established by the solemn Declaration of Independence. The Congress, under the Articles of Confederation, were the representatives of the several states, and having the power to make war and peace, were a party to the Treaty of Peace in behalf of the Confederated States, and every stipulation in the treaty inured to the benefit of the states in their sovereign capacities. When, therefore, it was agreed by the Treaty of Peace of 1783 that Great Britain should withdraw and with all convenient speed its garrisons from the United States and from every port, place, and harbor within the same, that agreement was for the benefit of the several states within whose limits those garrisons were. The section of the Articles of Confederation removes every doubt upon this subject. It provides that, quote, each state should retain its sovereignty, freedom, and independence, and every power, jurisdiction, and right which was not thereby expressly delegated to the United States in Congress assembled. And it is not within our knowledge or belief that the United States have ever claimed or set up any pretension of property to any fort within the boundaries of a state under these treaties.
All right. This case, what was the issue in this case was that a soldier in the army had killed a prisoner with his bayonet. And the federal government made the claim that it's a federal case because it's on a military base. You know, New York State claimed that New York State has the jurisdiction because the military base is on the boundaries. Military base is in the boundary marker land boundaries. So yes, it's a military base, but where is the military base? Or by the New York State made that claim based on the 1783 peace treaty, that Article 1, that United States viz, namely, name each one. So it's never, Great Britain did not relinquish to the United States, but to the individual states. New York State claims rights under the Duke of York Charter. New York State claiming rights to operate in the boundaries of the Duke of York's Charter through Article 1 of that definitive peace treaty. It never went to, why didn't it go to the United States Supreme Court? What the United States Supreme Court going to rule against? But they're going to rule against the treaty? Remember, the New York State, this is a proper ruling. New York State making a claim on the treaty. So there's the language. So that's why I had the Mander read it without it. We read it without the viz in the 13 states. Well, them, he treats with them. The word, you had the word states, plural. So that's why the answer is neither. Because it reached United States, not a trick question. The United States. Question number 3. You know what? Yeah, question number 3, and that'll be the last question.
Okay. Let me go back to the questions. Boom.
Okay, number 3, do the original 13 states derive their authority to operate in the territorial boundaries outlined in the 13 English-British charters from their states' constitutions of 1776, Declaration of Independence of 1776, the Articles of Confederation, their more recent states' constitutions, or the United States Constitution drafted in 1787?
Well, what did New York claim? What did New York State claim? The treaty, 1783 treaty. New York, in that case, People versus Godfrey. New York makes the claim based on the 1783 peace treaty, not on, they reference Article 7 or the Articles of Confederation, because in the Articles of Confederation is where they are, because they use that the language that is in the definitive peace treaty, Article 1, United States viz, that is in the Articles of Confederation. They function, they drafted as to operate as a league of independent states. That's why it's viz. It's United States viz, when that means namely. Each one is namely. That's what that means. If they didn't put viz there and name it, then they're not operating as a league of independent states. That has meaning. So it's understanding the language. That's why they put viz there and name each one. That construction means a league of independent states. That construction. If you take that out, it's not what? A league of independent states. So it's understanding what viz means. Why is that necessary to put there? So it's slowing it down and understanding the language there. This is where grammar comes in. This is why I taught grammar. All right, so we're gonna wrap up. Definitely, this was a wonderful class. I implore you to watch this again. This is share it, like, comment, and subscribe, y'all, and share this. Share this video, post it, your Instagram, Facebook page. You know, definitely do us a solid. You know, help others. Help others. All right, coming up February 19th. Yours truly, when we joined by our host, Seymour Bay and Brother Montevieux, who will be accompanying me as a guest speaker. This is in Jonesboro, Georgia, on February 19th. All right. So, T, you want to read because I can't see it.
All right, once again, here we go. The host is Seymour Bay, Brother Seymour Bay. The topic will be, keep on saying will be. The topic is the untold history and science of Black America. February 19th, 2003. Doors open at 7 p.m. 7827 Old Merrill Road, Jonesboro, Georgia, 30236. Your hosts will be joined by brother, yours truly, Abdullah El Talib Mosey Bey. He's the key speaker. Also, guest speaker is none other than, I cannot pronounce his name, Makaku.
Yeah, the more.
Yes, the more. All right, it's the Royal Ambassador at Large at Edgar Kingdom Alliance. All right, so
750, read the whole thing.
750 kingdoms in the alliance. Here we are. That was a little small. Search on Eventbrite. Title: The Untold History and Science of Black America.
The sponsor, but read the sponsor.
Yes, the sponsor is Power WSTV 104.9 Atlanta. All right, so it will be for the pricing is for 21 plus, 21 and up, will be 50 notes. 13 plus will be 25, and then 13 under 13 children are free. All right. And let me see if I have your books, Abdullah. Let's see here. That's a little small here. Uh-oh. All righty. Well, talk about your books real quick, Abdullah, while I get the
yes, go to mooresandmasonry.org for Moors and Masonry Part 1, the Masonic Compass Square and the connection to measurement and timekeeping, the Illuminati and illumination of the mind, how her Venus to move rule, etymology and vocabulary. Etymology and vocabulary supplementary 1 coming your way. Next month is Moors and Masonry Part 2. The Moors and Masonry Part 2, the power of Moorish treaties and the recovery of lost Moorish sovereignty.
All right.
And then coming your way February, set in the fall, the definitive peace treaty between Great Britain and the United States as the ruling instrument for the United States. That's coming this fall. All right. So Part 2, Moors Masonry Part 2 coming in next month. October. You can pre-order. Go to mooresandmasonry.org. mooresandmasonry.org.
Also, this class will be uploaded to YouTube tomorrow. So those of you who's watching it on YouTube, please like, please comment.
And subscribe.
Please comment. If anything, please comment.
Yes.
Put your comments out there. We will read them. And maybe you might see your question or your comment, read aloud and answered. So please do that. And let's see. We're done. All right.
The URL for the website, what's that? mooresandmasonry.org.
Moors Well, mooresandmasonry.org is under your books. Here, hold on.
I mean, that's what I don't know what, I mean, yeah. All right, thank you, Amanda. You can click on that.
The website tomorrow also will be up.
So explain, go more. You said the website, what's the
that Yannick?
website? Yeah, Yanni, you
More-
said the website.
All right.
The Moorish Southeast Regional Civics and Education.org.
All right.
You want to put that in the chat, Yannick?
Yeah, I put it in there, bro.
Yeah, so that they can get the link. I know it's long.
Mhm.
So you're gonna always have to put that in the chat.
All right. So yes, put that in the chat and we'll put it on the in the description as well. So we can paste it on over to the description. So this one is the mooresandnation.org. Thanks a lot, Amanda, for putting that in the
So
chat.
that's it. All right. Thank you, Amanda.
It was already at the bottom of your book.
You're
I
welcome.
mean, shucks.
All right. Peace, everyone.
Peace, everyone. Like, comment, and subscribe. All right. We'll see y'all in 2 weeks. 2 weeks.
Honest. Good show.
All right.
Oh, this was excellent, man. I gotta watch this again, man. I gotta watch shucks.
Peace. Thanks for the invite.
Yes, you're welcome.
Peace.
Peace.